The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Now sitting.
Please be seated. Good morning. Welcome to Kansas Supreme Court. We're pleased to have several visitors today from Justice Rosen's high school. And I know he's visited already with the students from Topeka West High School, but if you'd like to come forward and introduce the group, we'd love to make a record for our audience of your visiting us today.
Good morning. May it please the court, I'm Connie Jacobson. I brought along with me seniors in U.S. government, along with my student teacher, Mr. Jason Dester, and another teacher, Ms. Becky Lindquist. And I thank you so much for your gracious time. Thank you very much.
And once again, now I can publicly welcome my fellow Chargers to the Kansas Supreme Court. And thank you, Ms. Jacobson. This is, you do this, I know, several times a year. It's very great to have you here and see my fellow Chargers. So welcome.
Thank you.
And part of the reason I asked you to come forward is I think you set a good example for other teachers.
Oh, thank you very much. I appreciate it.
Could also participate. And so thank you for doing
Yes,
that.
we're lucky to have the support back at our administration. We're lucky for that. Thank you very much.
Thank you. That I'll ask Mr. Doug Shima to please call the 9 a.m. docket.
Thank you, Your Honor. The 9 a.m. docket for Thursday, November 2nd, 2023 has one case, appeal number 126643 in the matter of Philip R. Sedgwick, original action and attorney discipline, no briefs filed.
Madam Chief Justice, Justices, may it please the court, Julia Hart, Deputy Disciplinary Administrator, appears on behalf of the Office of the Disciplinary Administrator, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is reserved.
Thank you.
Madam Chief Justice, pardon me, Your Honors, may it please the court. The respondent appears in person and by John Ambrosio. We are ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Council would come forward then in 126643. Start whenever you're settled and ready. And
Madam Justice, may it please the court. This is a disciplinary action that was entered into and worked on very carefully by the parties beforehand in a profession such as the legal profession, where we are a profession that regulates itself. There's always value in trying to find where we can reach agreement and accept responsibility where we need to beforehand. In this case, there were 2 disciplinary complaints that were docketed, DA 13686 and 13702. These cases were docketed, investigated, set for formal hearing. The parties entered into a joint stipulation prior to the formal disciplinary hearing. The parties agreed to facts and rules violations. Specifically in DA 13686, the parties stipulated to rules violations of Kansas Rules of Professional Conduct 1.1 competence, 1.3 diligence, and 1.4 communication. In DA 13702, the parties jointly stipulated to a rules violation of 1.3 diligence. Prior to the formal disciplinary hearing, Mr. Sedgwick filed a proposed probation plan. This was a plan that Mr. Ambrosio, Mr. Sedgwick, and the disciplinary administrator's office spoke about and agreed to beforehand. Regarding the facts of the case that the parties stipulated to in the first docketed complaint 13686, the respondent represented a gentleman with the initials of TW in a child custody modification and support modification motion. He also represented TW in a misdemeanor battery matter where the child's mother was the victim. Prior to the hearing on the modification motion in domestic court, the respondent filed a proposed parenting plan. This plan contained typographical errors in the plan and in the certificate of service, notifying the parties of the time and location of the Zoom hearing. This pleading also contained inaccurate statements such as that his client completed court-ordered therapy when in fact he had not. The parenting plan alleged that TW applied for and received disability for payments when in actuality these payments were denied, but he was currently appealing the decision. The parenting plan alleged that TW and the mother got along when in reality, TW had pending battery charges against the child's mother. After the hearing and hearing the evidence and examinations from the party, the trial court denied the proposed motion to modify and made findings that TW's testimony that he completed court-ordered therapy was untrue. During the investigation phase of this docketed complaint, the respondent acknowledged that he used inappropriate phrasing in the motion, that he made typographical errors in the pleadings, and that he didn't properly prepare TW for the hearing or read the therapist's notes or discovery prior to the hearing. In the 13702 docketed complaint, the respondent represented an individual with the initials TB in a PV evidentiary hearing. The court revoked the respondent's revoked TB's probation and remanded TB to custody for his underlying 161-month sentence after the evidentiary hearing. The respondent timely filed a notice of appeal and requested a court-appointed appellate defender for TB in June of 2019. In July of 2019, TB filed his complaint with the disciplinary administrator's office against the respondent. In September of 2019, TB wrote the disciplinary administrator's office stating the court had not appointed him an appellate defender. The disciplinary administrator's office wrote back and told TB that that was not a violation of a KRPC, so no complaint would be docketed at that time. In October of 2020, TB wrote the disciplinary administrator's office again, stating that no appellate defender had still been appointed. In April of 21, the disciplinary administrator's office wrote the respondent and inquired of the respondent to provide information as to why no appellate defender had been appointed. And later on that month, in April 30th of 2021, the respondent wrote the disciplinary administrator's office to say that he had contacted the trial court and an appellate defender was now appointed. During the subsequent investigation of this case, the respondent admitted he should have followed up with TB sooner and the trial court sooner on the appellate defender issue. During the formal disciplinary hearing on this matter, the respondent stated that the probation plan he filed would ensure that he complies with the Kansas Rules of Professional Conduct in the future. Additionally, the respondent's probation supervisor testified at this hearing. He is located in the same office building as the respondent. He noted that he had concerns that the respondent has disorganized files and a messy, cluttered desk. And he believed that the respondent should further reduce his caseload so that he could focus on organization and making certain that no cases fall through the cracks.
Counsel, I'm sorry, I see your time and I have a few questions once we get into, I don't want to move you too quickly to the probation plan and the recommended discipline in this case, but so there was the original probation plan and then amended plan was filed. And when I look at those two, the only difference I can see is in paragraph 6 of the amended plan, the phrase during the pendency of probation is added in connection with the supervising attorney's duty to prepare monthly statements. Am I missing any other difference between that original and amended probation plan to your knowledge?
I don't believe so, and that may be a question that Mr. Ambrosio may be able to speak to more fully.
Okay, and I have a series of these, so if you bear with me a second. And then the proposed plan also limits the scope of practice, at least civilly, to small injury cases. It's not a defined term in the agreement, but it looks like there was some discussion that that would mean cases in which liability is admitted, not contested, and the only issue is damages. Is that your understanding of the meaning of?
That is my understanding, and that was a discussion that Mr. Ambrosio and I had leading up to the formal hearing as far as what was that meant. And I would note that in visiting with Mr. Ambrosio and his client leading up to the hearing, the respondent intends to take on no more personal injury cases and is vacating himself from that area of practice.
Okay. And then I think maybe my last question is the probation plan says that the respondent will meet with a supervising attorney in person every week during the first year and a half of supervision, and then at his supervising attorney's direction during the final 6 months of probation, which totals that covers a 2-year period, but the probation plan is a 3-year term. So I'm not sure, is there a final year of probation where there's no supervision, or how do we line those up?
I believe that that's covered in the portion of the plan that talks about monthly reports and the filing of the compliance from the practice monitor or the probation supervisor.
Right. And it looked to me like if you add up the duration of those requirements, it's 2 years.
The
Or am I
plan,
missing a provision that covers an additional 12-month period? Or I can ask,
certainly, and I'm sure Mr. Ambrosio can follow up on that, but
Okay.
the intent was a 3-year probationary period. There was some discussion about this at the formal hearing, and I believe that that is what the hearing panel also recommended, was a 3-year probationary period.
and do you have any objections to the panel had some proposed amendments to the party's plan? Do you see any issues or have any objections to those additional terms that the hearing panel proposed?
I do not. And going back to how I began my time with the court here today, I appreciated the panel being so active, and in a self-regulating profession such as ours, with the whole goal of probation being, let's correct whatever caused this person to violate the rules in the first place. They saw this as a tool that would help correct and ensure that this respondent did not appear before the court again.
Thank you.
I have a couple follow-up questions to Justice Wall's questions. Preliminarily, I want to summarize what I understand the violations to be and then just ask you if that's correct. I understand the violations to be essentially that in a child custody case, there were violations of rules of diligence and communication that resulted in the proceedings being delayed multiple times. And then in the appellate case, there was a request for court-appointed counsel filed, but because it wasn't acted on by the court, there was a year delay due to respondents' failure to follow up.
Correct.
If this had been a case in which the respondent contested discipline and there was no agreement, would a 3-year suspension be appropriate under the ABA standards for these violations?
I believe under the ABA standards, it speaks of a period of suspension. In this instance, when Mr. Ambrosio, Mr. Sedgwick, and I were crafting a joint stipulation, this was a period of time that would ensure that Mr. Sedgwick would understand the seriousness and the need to follow the probation plan.
Well, can I just, that sounds like a no to me. That sounds like your answer is no. These violations standing alone would not justify a 3-year suspension.
I stand behind the recommendation, and I feel as though that they,
Well, I do understand that
Respectfully.
it comes about because the end goal being the probation plan. I understand that. My concern is just that before we get to probation, I mean, these decisions have precedential value and so on. And I'm
certainly,
curious, it just strikes me that if we didn't have a probation plan here, I can't recall at least a time in which these kinds of rule violations, which are serious and do merit discipline, but a three-year suspension is that's pretty close to a death sentence. There's no probation plan.
Well, Ms. Hart, let me ask you a question. I might have read the facts a little bit differently, and you can refresh my recollection. But in the case with the child custody, it wasn't just that the child custody matter was continued a year, but because he represented the, well, he didn't prepare the individual for cross-examination, and he also represented the individual in the domestic battery charge, that if he would have not violated 1.1 competence and the diligence, that perhaps his client wouldn't have, would have had a chance to have 50% custody of his child? Or is that not true? I mean, was that, I mean, you're the one that conducted the
Certainly.
investigation into that, right?
there was an investigator appointed to this. Mr. Duma, I believe, was the disciplinary investigator, but I did present the case and prosecute the case in front of the panel. And in this matter, one of the serious factors that was considered here was, as a result of this, his opportunity to have custody awarded to him in this hearing was affected by this lack of preparation, by this lack of diligence, lack of competence in preparation. Is that what you're asking,
Right.
Justice? Yes, and that is a serious harm. Similarly, in the second docketed case, we have a matter where somebody has been remanded to custody for 161 months. And while their appeal was docketed, no appellate defender was ever appointed for almost a 13-14 month period. And that was despite the fact that TB was writing letters to the respondent, to the disciplinary administrator's office, to the court. And at that point, the respondent was the attorney of record on the case. If you look at comment 3 of KRPC 1.3, it talks about how when you are an attorney for a client, you have a duty to advance and champion for your client's cause till the very end of your representation. And in this case, Mr. Sedgwick was still on the hook. He was still representing TB and failed to act even after receiving communications and notification that an appellate defender hadn't been appointed. And in the end, ultimately in this case, while the court found that no error had been committed to overturn the remand to TW for to serve his underlying sentence, that's hindsight. And this is a person who could have sat in custody and been in prison for over a year for the simple fact that a appellate defender hadn't been appointed and his trial counsel did not follow up.
And it's my understanding, for as far as the investigation goes, and whether when you take into account everything and you think about the cause, which you opened up with, what is the cause of the misconduct and the violation of the rules, The reason we know the cause is because his supervising attorney really just said he's really disorganized. Is that what we know about the cause, or? And that's why probation is appropriate here, or?
We know that several errors were made in these cases that the respondent conceded to. We know that there has been prior discipline.
Right, and that was another thing. Was he on diversion when this even happened? Is that?
He was on diversion in 2017 and 2018. And
But
these
was his diversion expired when these violations occurred or not?
I believe so.
Okay.
I believe it had expired by that time, but we are looking at an individual that had an informal admonition in 2002 for the rules of professional conduct violations of 1.3 and 1.4. In 2007, he had a diversion for 1.3, and in 2018, he was placed on diversion for 1.1, 1.4, 8.1, and 8.4A. So this is an individual that has had prior matters. In speaking with Mr. Ambrosio and Mr. Sedgwick in crafting the probation plan and reaching stipulations and reading the investigator's report and visiting with Mr. Sedgwick, there were indications that disorganization and lack of good systems may have contributed to.
What else contributed?
Mr. Sedgwick types all his own pleadings. He does not have staff to assist him. He had self-indicated that his higher caseload may have caused him to not be able to keep track of all his cases as well as he should have, that sort of thing.
And then to Justice Stiegel's question about if there wasn't entered into a
Joint stipulation.
right yeah. In this case, it was recommended the 3-year suspension that's going to be I'm having trouble with words today. Stayed. It's going to be stayed. Would this more appropriately be a probation case without the suspension? Given the diversion and the history and the, what caused it and.
Right. No, this is an instance where, and this came out during the testimony in the formal hearing too, that Mr. Sedgwick is someone who represents a portion of our population that may not have the means to hire counsel. Normally, he provides counsel at a lower rate to meet the needs of the people in his community. And in doing so and having that word and good reputation out that he is willing to help those who need help for.
I think you misunderstand my question. What I'm saying is, instead of suspending him and then staying it and imposing probation, would it have been under the ABA standards, just a probation case? So
Well,
like when you're looking at the ABA standards, suspension is appropriate when a lawyer knowingly fails to perform services. Well, I guess in a pattern of neglect that causes injury to a client.
And that's what I was looking at, was that pattern of neglect. And in regards to your question, is this a case that's appropriate for probation? Absolutely. This is a case that is appropriate for probation. I think all three of us at council table recognize this and would be the first to tell you this. However, if for some reason Mr. Sedgwick does not successfully complete his probation and it's just straight probation, what what is the repercussion or the consequence for that? And that's why there needs to be that suspension period that is stayed and underlying it. And as this court, I believe, is aware, it's not often that somebody fails probation to the point that that suspension is put in place. But if that does occur in Mr. Sedgwick's case, having that reinstatement hearing there gives Mr. Sedgwick the opportunity to present to not only the disciplinary administrator, but to this court that he has dealt with and has a plan in place going forward.
Thank you.
And I think that still doesn't get to the question of why not a 6-month probation? I mean, I'm sorry, a 6-month suspension or a 1-year suspension. Why a 3-year suspension?
I think in reviewing this and determining what was appropriate, this was the amount of time that, while I very much agree with Justice Stiegel's comment that this is where decisions that are made set precedents and parties look at and rely on, we also look at each case individually and look at the facts and the rule violations and the consequences essentially individually, you know, much as is somebody an appropriate candidate for probation? What is the appropriate period of suspension that will get this person's attention and motivate them moving forward to comply with probation and rectify whatever caused them to be before the court in the first place? And in this instance, and looking at the pattern of neglect that has essentially occurred in these cases and looking at the periods of time where these rules have been violated previously in 2002, 2007, 2018, a 3-year period when looking at all these factors seemed appropriate as the underlying period of suspension.
Thank you.
Thank you very much.
John Ambrosio, on behalf of the respondent, may it please the court, Madam Chief Justice. I'm going to try to answer all of your questions because, as you know, I enjoy answering questions and giving you something to think about more than I enjoy just getting up here and doing it through rote. But I want to start by first saying my client would like to address you if I have some time at the end. I think it's very important and it's part of this rehabilitation for him to address you. Do I have your permission for that? Before I answer your questions, I think it is absolutely terrific that the disciplinary administrator's office just doesn't try to take licenses or mete out serious discipline. I think it's important that they work with lawyers like me who represent lawyers to try to craft something to save the lawyer while protecting the public and while making sure this type of activity doesn't happen again. Justice Stegel, I think I understood your question. I never take notes, as you know, but here's the answer to that. This was serious conduct. I don't know what this court would have recommended, but if I was a panel member and had listened to what the conduct was in both of these cases, I think my recommendation without a probation plan would have been an indefinite suspension. And I think because my colleague worked with me on this, 3-year suspension, indefinite, they're the same thing. They're the same thing. And at his age, which is 68 or 9, it's a death sentence, as you indicated. So I think it was serious. It doesn't matter if it's 6 months.
I'll just interrupt you and just
sure you will.
press
Go
a little bit
ahead.
on that. You tried this case. You're obviously have an intimate knowledge of all the rule violations, so on, far more than I do. But my understanding of this is that this is a disorganized lawyer who has no staff, who made some clerical errors, committed, yes, serious violations. There was a delay in his client's appeal, and he bears responsibility for that. Although I will also say that I think once a lawyer files a request with the court to appoint appellate counsel, he still has a responsibility to follow up, but maybe there's responsibility to be shared there.
But I try not to point fingers like that.
Sure, but I'm just trying to understand the global nature of the misconduct. And honestly, it doesn't strike me as an indefinite suspension type of a case.
Okay, because I look back at the Lowry case, which was pretty serious misconduct too. And in that case, I believe it was my case, I believe there was a suspension and stayed that suspension and allowed him to practice on a probation plan.
Right.
I think with serious conduct like this, I think what we were trying to do is protect Philip, Mr. Sedgwick.
Yeah.
And we were trying to protect everybody.
And I
And
appreciate
sometimes
that.
you got to hold
Yes.
something serious over somebody's head, Justice.
So I appreciate that. And I appreciate all of the efforts that are done in good faith. My questions aren't intended to be critical of that,
sure.
but to me, there's a fundamental point here, which is the punishment comes first and then the probation. And I want to run a scenario by you and have you correct me or tell me why this is an inapposite comparison.
I've never been shy. I'd be happy.
Right. And I think of this as if compared to a criminal case where, let's say, someone has a low-level felony, the sentence grid box has them at 12 months. And the prosecutor and defense attorney basically say to the client, look, if you're willing to agree to these probation conditions, the state will give you probation and we're going to sentence you to 10 years, but you get probation. Is that a fair analogy?
I think that's a good analogy.
Okay.
I think it's good. Because I think you and I did that when you were a prosecutor, I was a defense attorney, because we wanted to hold something over somebody's head. And I think that's important for Philip to know you don't get a second chance. And I think, I shouldn't call her Julia, Ms. Hart was trying to make sure he got that message. I really believe it. And on the probation plan, and then I'll get to you last, on the probation plan, I think what happened, we worked on it very hard, the two of us. And Philip helped us, but it was putting it together. We were looking for something to save and protect. And I think what happened, somehow one of the pages didn't get filed. And I think we had to go back and refile it, and there was a slight change, but nothing major. So I hope that answers that question. Now, to come to your question,
Although I will ask, how long has the respondent been working under that probation plan to date? Are we almost a year into it or not
a
quite?
little over a year,
little
I
over a
believe.
year.
Little over a year, and it's really working. It's really working. And Philip, other than he didn't know what KLAP was, and that's why the panel put in that provision where they want him to get a management course. He's working very hard with him. And what we're trying to do is, what we want to do is, we want to hit him hard in the beginning. Weekly meetings. Tell me what your schedule is. Tell me where you're going to be in court. Have you prepared your witness? Have you prepared your client? That's what we were aiming to do. And then as it gets longer down the line and he's on a second year, then we're going to have less meetings. But the probation supervisor is always supposed to be available. I did it 3 times. I'll never do it again because it's thankless. But you're always available to that lawyer that you're monitoring for any question. And as a matter of fact, it is the lawyer's obligation and the supervisors to make sure they stay communicating. We wanted to wean them off it. And frankly, Your Honor, he may not, I don't mean that you're going to die, Philip, but he may not continue to practice that full 3 years. We don't know, but we wanted to make sure we were protecting everybody while this happened. Hope that answered that question.
It does. And one last question. The panel had a couple of additional recommendations. Are you in agreement?
Absolutely in agreement. My colleague and I were not real thrilled that he had some personal injury cases. So we talked to him after the panel hearing, and one of the panel members said, you know, John, she said, Mr. Ambrosio, it's difficult doing personal injury cases. That's the most dangerous type of work in addition to the domestic. My client is not taking any new ones, but he's going to have to finish the ones that he has because frankly, I don't think we can get anybody else to do those. So we're doing that. Also, he had a Jessica's Law case. I was not thrilled about him having a Jessica's Law case. So I convinced him and he got off that case so that he can handle only cases of a lower level. Not that those people don't need good representation, but there's less danger. You don't have to get the psychologist. You don't need 10 investigators. So that's what we tried to craft. You're going to have to help me because I don't even take notes, Your Honor, while you were talking. I hope I answered your question by answering those other questions.
My question had to do with whether or not the father lost custody because of incompetence.
Hard to tell because that makes me speculate on what the judge is doing. I think the father was not going to therapy, had been less than truthful about whether he was in therapy, and indicated that he was getting along just swimmingly with his significant other, who was the mother of the child, when he had been accused of a domestic battery in municipal court, which, by the way, he was later found not guilty of, I believe. So I don't think he lost custody, but I think because of his actions.
Well, right, but that all happened on cross-X.
It happened on his watch. I'm not suggesting that my client has clean hands. He had an absolute obligation to make sure his client goes to therapy. He had an absolute obligation.
No, I'm not talking about an obligation to make sure you can't make your client go to therapy. I'm saying on cross-X, he said, you know, I'm going to therapy. I get along with my ex-wife fine. You know, he just lied on cross-X. And it's like, you know, he didn't prep his witness.
No, I agree with that. I agree. I think we're agreeing the same thing. He did not do what he was supposed to. And that's why we crafted this type of probation plan to try to help him and to stop it. My colleague is right. I'm lucky. I'm in an office with 40 lawyers, and I don't know how much support staff we have. Not everybody is as lucky as us. Not even as lucky as me. He's in a small office. He has to do his own typing. If I had to do my own typing, I'd start drinking at 4 a.m. because I can't type. Okay, it's really bad. And he can't type. He's sloppy. And then he puts some things in there to be cute. The dog in the manger thing that are absurd. I know it's a Greek fable, you know, but the point is that's not appropriate in pleadings. But he stood up to the plate and he's admitted to my colleague, he admitted to the panel, and I think you'll hear him admit to you, what I did was wrong. I think the probation plan my colleague and I, along with Philip, have crafted would make sure this behavior doesn't happen again. Because a probation supervisor would say, how about this client that doesn't have a lawyer yet? What are you going to do? Don't you think you need to go over to the judge's AA and say, hey, ma'am or sir, can you get the judge to appoint the appellate defender? This guy is in the hoosegow. He got a serious sentence. It's his right to appeal whether or not he'll win. He needs somebody. You got to keep after that. Judges make mistakes too. And our obligation is to go to you and to say, you need to appoint somebody. I've been over here 3 times, maybe not quite the way I would do it, but you've done it. You know, you've missed this 3 or 4 or 5 weeks now. Please appoint somebody. Please appoint somebody. Send an email to remind the judge. He should have done all of that. And a supervisor would make sure that he would do that. A supervisor would say, have you prepared your client? Have you investigated the things he's saying? Is he in therapy? Is he not in therapy? How about this domestic case? He'd make him do that. That's why we crafted this type of probation plan, which I think helps. I really do. And what my colleague was talking about, I think it's paragraph 93. And I never not thought about this before, that there are certain lawyers that take care of a part of the population that legal aid doesn't touch, public defender doesn't touch. Those of us who are in larger firms, or those of us who have different type practices, won't touch those type of cases. He fills or fulfills that need by taking care of those. And that was an interesting thing that it's in paragraph 93, because I had not thought about that before. We have some of our members who take care of members of the population that would fall through the cracks. And I think that's why my colleague worked so hard to do this. And I think she should be admired. And I thank her, and Philip is going to thank her for what she did. And I'm hoping that you will allow us to put this continue this probation plan working. You will allow us to let them to continue to serve the citizens of Wyandotte County. I think I sense the question over here, but maybe I'm wrong.
No, only that I hadn't heard you mention that one of the additional proposed recommendations of the panel was a KLAP practice audit with a different supervising attorney. And I just hadn't heard you mention.
We're okay with that too. We're absolutely okay. And I think they'll meet with the people over there. They have a good good setup over there, in addition to helping people who have substance abuse problems, and they've really been helping in the management of some of these smaller offices. We've only got a couple of minutes left. My client would like to address you with your permission. Philip?
Thank you.
It is more fun when you guys ask questions, so. For me.
All right, thank you, Mr. Ambrosio. Thank you, Ms. Hart. And thank you, members of the bench, for your time and listening to this. Basically, what I started out in practice, actually working as a law clerk. And then from there, I'd really always hoped to work in a legal aid or a public defender situation where I did have anything. I really didn't have any clue about how to run a business, and it's hurt me in a lot of ways as I practiced that. But it was also my goal to work with people who were poor and needed help, and that was why I went into law school. With regards, I think what happened in trying to start a business is I took everything that came through the door, and I did such a wide variety of types of law. As I said, doing my own typing. I'm not a great typist, and those issues, and trying to maintain my own organization. And I think that was very difficult for me. I really wasn't prepared to run a business in this manner. I did take specifically with regards to this case, and in addressing your case, my client was asking for parenting time. He wasn't really asking that he have custody or 50-50 custody. And I don't think he was in any position to ever think about getting that. He had not seen his child in 3 years when I got the case. So it wasn't really any allegation that the mom was particularly unfit or wasn't doing a good job with the child. It was more just to try to get some time. And where I think I fouled up was is that I did not look at the reports early enough in the case to spend some time with him thinking, hey, you need to go back and find a new counselor looking at the reports. You need to get back and start over with all these things because you're not doing very well at them. And he, in fact, got kicked out of therapy. He had a different version, but that was basically the problem is not spending enough time going over with him what the indications were in the report and following through with getting him to correct his deficiencies that were apparent in the report. And that, I think, would have got him into maybe a quicker situation to be with his child. With regard to the notice of appeal, I filed the notice of appeal. I actually thought that the appellate defender, in fact, when the first complaint was filed, I thought that it was, but I could have, especially on a notice of appeal on a probation violation, I think I absolutely should have made sure that the bailiff caught on that there was a notice of appeal, because not all probation violations end up being appealed. I mean, that's, I think they're quicker to catch on when you do a jury trial in front of them that, hey, we need an appellate defender appointed. We know we're going to do that. Not every probation violation goes that way. So that was where I let down in both of those. I'm sorry for what had happened. And I do agree that those things were on me to get those done. As far as where I want to, I believe that the probation is beneficial to me in a number of ways. First off, finally, fortunately, I'm kind of in a place where in my life where I can restrict how many cases I have a little better than I could when I started. And I don't need to do everything anymore. And so I think that's actually something that I'm really looking forward to more than anything, is just, I stick to criminal and traffic. I think that will be a much more comfortable fit for me in terms of my practice and in terms of me being able to make sure that I'm aware of, the different directions those can go. I believe that the meeting with, as stated, I was in my own office, I was doing my own typing, I was keeping track of my own calendar and doing everything. Having someone to talk over with my cases is, I think, going to be a huge benefit to me, and I'm grateful for that. And, if you have any questions you want to ask me, feel free to ask them. And
Well, I do. And it just strikes me, the concern I have here is that you had a diversion in 2003, but in 2017, a diversion, 2018, a diversion, and maybe I got World Series on my brain, but that seems to me 2 strikes. You should be aware, by just the virtue of having 2 back-to-back diversions, you have a problem, and it's taking this to address it. Why is that? What did you learn? It seems like you suffered no consequence or didn't take any lesson from the warnings that were given you through the generous offer of diversions. I mean, what do you have to say to that? Why are we here?
Your Honor, it has, I agree. I do think that it's just been hard trying to manage all of my own office. And like I say, I think one place is that I am in a different place where I can restrict, where I'm not trying to do as much type of areas of law as I was in. I can only say I'm sorry for being back here. I can't try to tell you that I have a great explanation for that. I've practiced for a number of years, but yeah, that I can understand your concerns. I can only tell you that I'm really trying to restrict what areas that I have and trying to cut down on the volume to where I can do better at things.
Thank you.
All right, thank you.
Thank you. Thank you to both counsel in this matter. I apologize that I failed as we started court today to explain that Justice Biles is under the weather today. He did listen, I think, by YouTube to the argument and will participate in the decision. That we will be in recess until 10:30.
All right.